Great. All right, we'll go on the record in the state of Wisconsin versus Dwight Walker Jr. It's 25 CF 2626 appearances.
The state appears by Assistant District Attorney Thomas Valerio. Good afternoon.
Mr. Walker is here in person with counsel Bill Ginsburg. We have a copy of the complaint, waive its reading. Not guilty on any misdemeanors.
What about the address?
Address is correct.
All right, there's a public safety assessment. It recommends a signature bond. State's position on bail.
Judge or Commissioner, I'm recommending a $4,000 cash bond in this case, along with the condition that the defendant not operate a motor vehicle and that he not use or possess any alcohol. Just out of the way, I'll recognize that there are no recent failures to appear. Looks like the last time Mr. Walker had a case in Dane County was in 2013. I don't see any previous Act 3 eligible offenses for which he was convicted of. And for the time that he was on bond in 2013 and prior, it looks like he got all signature bonds. What I will mention, though, is that this is an Act 3 eligible offense because there is a charge of second-degree recklessly endangering safety. It's a situation where when he's approached by law enforcement, Mr. Walker allegedly comes up with a story that he was apparently jumped by a group of people who stole his truck and kidnapped his fiance and wife. He knows these people crashed and didn't know what happened to his wife. He says he decides to walk away after these alleged kidnappers crashed and ran, didn't even check to see where his wife and fiance was, and decided to walk away from the scene, which was his residence, because he was, quote, scared of police. Witnesses then who sees the vehicle after it crashed into the tree, observe a female unconscious hanging out of the passenger side door that was open, not moving. And then 45 minutes later, witness sees the truck back up from the tree and starts to drive off and indicated that it was, quote, all over the place, unquote. The female victim was still hanging outside the passenger side door at the time as well. This is an objectively serious offense, and I think that cash is appropriate given the Act 3 eligibility of this case. If you're not inclined to order cash or lower cash, I would propose a referral to pretrial services for alcohol monitoring to ensure his sobriety. I think that's absolutely needed, and without high cash bail to ensure the public's protected during the pendency of this case. I should also note that the victim in this case wants contact with the defendant. As you know, I'm not asking for any conditions regarding contact or no contact.
Got it. And Attorney Ginsburg.
Thank you, Your Honor. Mr. Walker is a lifetime resident of Dane County. He has 3 children that all live in Dane County. He has his own business, P&B. They do landscaping and snow removal. As you can see from the criminal complaint, apparently there was an OWI about 14, 15 years ago. It's my understanding and even if the story about being robbed sounds totally implausible, it looks like I don't know where they come up with the recklessly endangering safety. We know that the vehicle hit a tree, apparently, according to the complaint, and then they were able to back up. And he's obviously, because you could see from the locations, it's at 401 North Thompson. They lived at 702, so they were 3 blocks away. I can see why he tried to make it home. And at some point, I think they couldn't get help, and he went to go get help, and that's when they they located him. That's really all there is to it. I obviously we don't even know what his alcohol level was, if there was alcohol. That's the basis for all of this. We'll assume it, even if we assumed it was, the idea of no driving at all.
Well, I think he admitted that he'd been consuming alcohol, but yeah, there wasn't a test.
But the idea of no driving at all, we don't even know what the test result's going to be. I realize there was an accident, but I think the no driving when there's just one prior 14 years ago is way overreach. I think that we don't have an objection to the no alcohol while the case is pending. But as I said, I think asking for cash is totally unnecessary here. As I said, I'm not sure there's even facts for the recklessly endangering. I think the state's only argument might be that when they tried to leave where the tree was, And they're just apparently didn't go more than a block. And the witness just says it's all over the road, but even that is not necessarily recklessly endangering safety. If they're driving 20 miles an hour or 50 or 25 miles an hour, you don't even have any facts to suggest anything. And the hit and run, with the allegations, you have to stay at the scene and provide information. There's nobody to provide information to. So for him to go home to try to get to the house and call for help, I'm not even sure it's really a hit and run.
Okay, any response from the state?
It's also required to provide reasonable aid under the hit and run statute, and that clearly didn't happen here. And furthermore, I'm sorry, if you leave the scene of a crash after you just struck a tree and the passenger of your car is still hanging out on the side of the road, or excuse me, on the side of your car while you're driving away, oh, and by the way, you're going all over the place, I think that deserves a no driving condition. I also think that qualifies as second degree recklessly endangering safety, especially when the driving behavior conduct resulted in her having a broken clavicle. That's in the complaint, along with fractured ribs. That's also in the complaint. Again, it's a serious case. So I think for that reason alone, the Act 3 eligibility of it indicates that cash should be applied. But again, if the court's not satisfied that cash is necessary or flow cash is required, I would again propose that he go on pretrial services for alcohol monitoring.
And any response, Attorney Ginsburg?
You know, if the facts are they have the crash and he doesn't have a phone to call 911 and he runs the 2 blocks home to try to call for help, is not necessarily the aggravated nature that the state would try to argue as inference. And I don't think there's any reason you need pretrial services on just what appears to be an OWI injury where it's just overreach on this one.
All right, let me take a closer look at things. All right, well, it's probably an unusual charge in regards to the second degree reckless endangering safety. I don't know if the theory is Mr. Walker's drunk and he gets in a very serious accident and that's what the second degree reckless endangering safety is, or if it's the actions afterwards where he's driving away from the scene all over the place with somebody who's severely injured and hanging out the side of the door. I think for purposes of today, there's probable cause. I took a quick look at the hit and run statute. I don't know that the jury instructions of the statute make clear this is unusual in that it wasn't a person who was outside the vehicle who was struck or another vehicle that was struck. But I guess I haven't heard a specific motion to dismiss that particular charge. It's certainly concerning behavior. The public safety assessments recommending a signature bond. The state indicates that there's no failures to appear, I guess. Recent failures to appear because I think the public safety had one, but if the prior criminal record, the last case was in 2013, it's over a decade old. He's got the signature bonds before. I haven't heard about a history of picking up bail jumping charges and violating conditions of bond. I guess I'm not satisfied at the end of the day that cash bail is necessary to protect the public. I am going to order pretrial services. It's a serious crash. Drunk drivers are extremely dangerous. And I think that's appropriate to make sure that somebody doesn't get killed because Mr. Walker decides to drink and drive going forward while he's out on bail. I'm not satisfied that cash is necessary when we have pretrial services. I expect he's going to comply with that given his prior history, but I think it's appropriate. So I'll order a signature bond. I'll order that he report to pretrial services. You got to be there by 10 a.m. tomorrow. They're on the 5th floor of the Dane County Courthouse. I believe they've given you the map. That's the yellow piece of paper. Make sure you're there. If you're not, then we don't have any choice but to issue warrants. I'll order that they equip you with the PBT or a scram bracelet or whatever they decide to use to monitor your alcohol use. Order that you not possess or consume any alcohol. Given, I think the OWI history is relatively limited. I'm simply going to order you not operate a motor vehicle unless he has a valid driver's license. I do that in part because he's going to be actively monitored for the alcohol use. And I think that is the greatest concern that the state has, and certainly it's the greatest concern that I have. What about time limits for a preliminary hearing?
Wait time limits.
They can give you the status date if you want to hang on.
Right now, I'm looking at it, January 12th, 120.
Sure,
Okay, we are adjourned.
thank you.
All right, squad. All right, squad. Next up is NYANTIK baiting.
Thanks.
Hi,
You don't remember which branch that last case was assigned to, do you? If not, it's okay.
It was five. Make up like 80%.
Aisle 80%. Got it. That is good enough for me. That's fine.
This is a bit under.
Is your mom's address still good for mailing?
Oh, I just changed it to the job center.
Job center? Okay,
That's
very good.
why I couldn't get over there. I didn't know.
Okay. Okay, very good. Thank you.
All right, we'll go on the record in the state of Wisconsin versus NYANTIK baiting 25 CM 1483. Appearances.
State appears by Assistant District Attorney Thomas Valerio.
Good afternoon, Your Honor. Niantic W. Bating appears in person in custody with attorney Charles Verhove, previously representing her on this case. Your Honor, this is the same complaint we're appearing on.
Right, I think the initial appearance has been conducted. A signature bond was set. We need to
Yeah.
address bail because there was a failure to appear on October 20th of this year. I also have a note that she did not contact the Wisconsin Forensic Unit to get evaluated
Yes.
for competency, and I think they needed some contact information. If you have that, that would be great. I think the clerk can put that in the notes. And we do probably need to make sure that the 5215 Bliss Street address in Madison is still a good address.
I was confirming that, Your Honor, that is her mother's address. She believes that 1819 Aberg, the job center, would be a better address for her going forward. It would be easier for her to get to that address. I think the issue with contacting the forensic unit has been the reliability of Ms. Bating having a phone. I would be happy to work with her to make contact with the forensic unit. I did speak to them on Monday when I learned that Ms. Bating, who called me from jail to let me know she was there, I called the forensic unit and they advised me to let them know what was the result of today's hearing. So I think coordinating with Ms. Bating and a forensic unit, I think we can get this appointment underway.
Okay, so there's no phone number right now that we could take down.
I just got a phone, but it's Wi-Fi. I don't have a phone.
What's that number, Ms.
I don't have a
Bating?
number. I'm home.
What's a Wi-Fi number? I understand.
628-622-8677.
All right, so we basically have a phone that is often inoperable.
Yes, but I will, as I said, I will coordinate with Ms. Bating at a time, either using her phone and Wi-Fi or my own phone to establish contact with the forensic unit.
Okay.
Your Honor, we would ask for a signature bond. She's not intentionally missing court. And as she's indicating, she's homeless. She doesn't have employment. She doesn't have a means to pay any cash bail at this point. And it's a relatively minor offense. We're dealing with the disorderly conduct.
Okay, what's the state's position on bail?
Well, I think in the 25 CM 1483 case, I don't think we've ever seen Miss Bating unless she was in custody. As soon as her bond is reverted or to a signature bond, she absconds next time. We also have bench warrants issued in October, September, and August of this year, along with bench warrants issued in March of 2021 and August 19th of 2019, for what that's worth. It's a sole count DC. I agree. It's not, it's a criminal offense, but it's not serious, relatively speaking. So I would ask for a very modest cash bond, like $250, $300.
And Attorney Verhoeven, anything else?
Okay.
If I just change an address to the job center, because I don't even know what's going to be on this.
Your Honor, I do know there's been two different bench warrants previously in this case. I acknowledge that I would just ask that this be Ms. Bading's last chance. She's promising that she's going to make sure that she doesn't miss any future court hearings. Even a modest cash bail of $250 is not going to be something Ms. Bading has the funds to pay for herself or through family. I think she was talking to me about a friend of hers that was helping her in the community that lives in the tiny homes village. And that person's not available to help her at this point either.
They should not have any.
All right, well, she's missed every court date except when she's been in custody. There's 3 failures to appear alone in this particular case. I think we've given a lot of slack, taking into account the limitations that Ms. Bading has and the fact that it's a disorderly conduct charge. I haven't really heard anything today that I expect she's going to make future court dates without cash. Well, but you made that promise each time you signed your bond, and you failed to appear 3 times in this case. And I don't think any of these, except for maybe the first court date, they were able to give her the next court date. It would have been set by the branch. And I don't think the clerk can give her a court date again today. So we're going to be kind of in the same boat. And I think the clerk was kind of nodding in agreement.
I was waiting for the computer to pull up the D4 record so I could confirm what you were saying. I will not be able to provide a court date today. And it does appear that all of the other notices have been mailed, with the exception of a competency hearing that had been scheduled for October 20th.
All right, well, so then she's also failed to appear when she had notice, but I'll set $250 cash bail. That's about as low as I can go. And then keep in contact with Attorney Verhoeven. If you don't know when your court date is, you can always come down to the courthouse. I think there's a kiosk that you can look things up, or if you can go to the library and look things up, or stop by the public defender's office. I'm sure they're willing to help you, or Attorney Verhoeven's office. We just have to have you appear so we can get this case resolved. All right.
Okay, thank you, Commissioner. Okay. I'll come and talk to you.
All right, next up is Carl Hickman, steering by Zoom for appointment share. Ready for this minute?
Right, we'll go on the record in the County of Dane versus Carl Hickman. It's 25 FO 2220 appearances.
The county appears by Assistant District Attorney Thomas Valerio. I appear in person. The defendant, Mr. Carl F. Hickman, appears via Zoom in custody without counsel.
All right, and Mr. Hickman, give me a thumbs up if you can hear me okay. All right, so some partial good news. They've decided not to charge you with a crime. They've charged you with a county resisting obstructing officer. That's non-criminal. It's more like a traffic ticket as far as severity. The bad news is there's a DOC hold. It looks like that's still in place. I don't have any authority to do anything with that. You're gonna have to talk to your agent about that. If you're not in custody, is the 1239 East Mifflin Street, apartment C3 address in Madison. Still a good place to get mail? If so, give me a thumbs up. If not, a thumbs down. All right, see a thumbs up. So on this particular charge, the non-criminal charge, they're gonna have an offer and we'll see what that is. If you want to accept it, then you can just be done with that particular charge. If you don't, it's not gonna affect your bail. We're not setting cash bail or anything. But you'd need to show up for future court dates, otherwise you'd get defaulted on the charge. Attorney Valerio, is there an offer?
County's offer is court costs only.
Okay, so if you wanted to accept that, that would be $114.50 to be paid within the next 60 days, or work out a payment plan if you need more time. If you wanted to accept that offer, give me a thumbs up. If not, a thumbs down in the window. All right, I see a salute. Is that intended to be a thumbs up that you want to accept that? All right. I'll accept your no contest plea to the charge, or you to pay the court costs. They'll give you some info about making the payments, and then you'll just again have to talk to your agent about getting the hold lifted. We are adjourned.
Next up is Jorge Aguilar Ramirez.
Okay, we'll call the state of Wisconsin versus Jorge Aguilar Ramirez. 25 CM 2758. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Aguilar Ramirez appears in person, in custody. We've received a copy of the complaint. I'll waive its reading. The address is correct, and he is not interested in SPD representation just for today.
Right, Mr. Aguilar Ramirez, the deputy is going to give you the public defender information on the Spanish version. If you change your mind, give them a call and they can evaluate you for a lawyer. But you're certainly entitled to hire an attorney on your own after today if you decide to do so. I'll swear the interpreter for our hearings this afternoon. We've got certified Spanish interpreter Fred Svensson. He is swear or affirm that you'll truly, accurately, completely, and impartially interpret the proceedings.
Yes, I do.
All right, I'll make a finding of probable cause. We'll get not guilty pleas entered to the charges. State's position on bail.
I have no objection to a signature bond in this case. I would ask that the defendant have no contact with the child victim. For the benefit of the bond form, their initials are ETX.
RTX.
ETX.
E is in Edward.
All right, and that the defendant be banned from the 2400 block of Fiedler Lane. For the record, that's spelled FIEDLER. I will note that the victim's mother is in support of the bail recommendations.
Right. And any objections?
One moment, please. Do you understand what they're asking for? You wouldn't be allowed si me libera, no tener un contacto con esta persona. Ajá. Entonces sí yo puedo, porque yo trabajo en otro lugar donde casi no frecuento, ¿me entiendes? O sea, no lo puedo, aunque él vive de este lado de acá y yo trabajo en
No puedes estar en la Fiedler Lane,
2400 block.
2400 Fiedler Lane. No puedes estar.
Yeah.
Y no tener contacto con TX.
Ajá.
Ningún contacto, no puedes ver a la persona, no puedes llamar, no puedes pedir sobre la persona.
Directo y indirecto.
Pardon.
Direct and indirect.
Directo o indirecto, no puedes.
Y no, dice que no puedo estar 2400, que los pies,
Fiedler.
pies, si no,
No puedes estar en esa cuadra, you can't be on that block.
okay. You okay with that? No, está bien. No objections, thank you.
Okay, we'll order a signature bond. Condition will be a no contact direct or indirect with the child victim with the initials ETX and a ban from the 2400 block of Fiedler Lane. And they're gonna have some paperwork for you to sign. I believe you'll get your next court date and then you'll be processed and released. And we are there.
Next up is Pineda. Thank you.
Is that, what was the last name again for this?
CANO,
Got it, with the C.
I think sometimes goes by CANO. Pineda is the last name, but
Okay,
CANO does not always need an interpreter, I guess you should just confirm that you.
So he wants a signature bond. ¿Sabe su cargos? When do you see? Lo siento, pero los dos también. This happens. Thank you.
okay, we'll call the state of Wisconsin versus Noe CANO. It's 25 CF 2615 appearances.
the state appears by Assistant District Attorney Thomas Valerio.
Mr. CANO Pineda appears in person, in custody, and by Attorney Connor Sheehan. He is eligible for state public defender representation. We have a copy of the complaint. We'll waive its formal reading.
Great. We also have certified Spanish interpreter Fred Svensson. I've already sworn him for our hearings at the jail. I'll make findings of probable cause, enter a not guilty plea to the misdemeanor. What's the state's position on bail?
I'm asking for a $1,000 cash bond in this case. I'm asking that the defendant not use or possess any alcohol, that he be banned from any bars, taverns, and liquor stores, that he have no contact with Marcellus L., and that the defendant be referred to pretrial services for alcohol monitoring. Commissioner, this appears to be the fifth pending case pertaining to Mr. CANO. Yes. And looks like alcohol might be an issue in this case. I will note that bench warrants were previously issued on October 5th, 2021 and September 2nd, 2021. September 2nd, 2021. Those bench warrants weren't served on him until January 27th of 2022. Furthermore, I'll also note that in 25 CF 1875, Mr. CANO did successfully post a $1,000 cash bond there on September 16th of this year. So I think the $1,000 I'm asking here is appropriate.
Great. And Attorney Sheehan?
Thank you, Your Honor. If alcohol is the problem, then pretrial services are appropriate, as is a no alcohol condition. $1,000 cash is a sentence. It is not a condition of release. Coming up with $1,000 as someone who is indigent, who hasn't actually worked since 2023, is bankrupting. There's no way that he could post $1,000 on September 16th and somehow come up with it again before any reasonable period of time, before these cases are resolved. To address the outstanding warrants or the bench warrants, even the time that they were resolved, it's still 2022. That's remote in time, I would hope, to say the least. And regardless of the facts alleged, we are still talking about felony bail jumping and disorderly conduct. These aren't the crimes of the century. I don't think $1,000 is appropriate. I'm asking for a signature bond with pretrial services.
Right. So it looks like, in several of his other pending cases that were referenced by the state, he's posted cash bail. Looks like that was a $250 amount and 25 CF 1814. And 25 CF 1724, $250. And posted $500 cash bail and 25 CF 1649. Any response from the state or the defense in regards to that information?
I think I might have, hold on. So are you saying that because the notation I have is that there was $1,000 actually posted in the 25 CF 1875 case. Do you have different information from that?
No,
Okay.
he posted 1,000 there, but he's posted cash, I think, in all the rest of his pending cases, $250 for a couple, 500 for one, 1,000 for one.
All right. No, I don't have anything else to add.
All right, Attorney Sheehan?
Nothing further, Your Honor.
I think the request is pretty warranted. He's shown an ability to post about $2,000 in cash over 4 other cases in relatively short order. I'm not saying that he posted it the very same day in all these cases. None of them looked like it was months where he was sitting in jail. I get it, it's a disorderly conduct, but we're on case number 5. You gotta follow the bond conditions. I'm certainly willing to try pretrial services if that gives you some assistance. They can kind of try to point you in a direction to get some alcohol counseling if you're interested. It's not something you do with them, but they're gonna monitor your alcohol use. If you post, you got to report there no later than 10 a.m. on the business day following your release from custody. It's on the 5th floor of the Dane County Courthouse. They'll equip you with a breathalyzer to monitor your alcohol use. Will order that you not use or possess any alcohol, that you be banned from any taverns, bars, liquor stores, or other places whose primary purpose is the sale of alcohol. And I'll order a no contact director and director with Marcellus L. Bond usually doesn't get better once you got cash and pretrial services. If there's violations, you really gotta make this work and reach out to pretrial services if you need help. Should we schedule a timely preliminary hearing in the next 10 days?
I would waive since he has counsel in the other 4 cases. I'll give them the decision.
Okay, we are adjourned.
Thank you. Good enough.
Ray, did you need a spelling for the?
Next up is Creed Moore, appearing by Zoom. No, I found a spelling for it. I'll say it out loud. The order's running. Marcellus, MARCELLUS.
Yes. All right. Thank you.
Thanks, Fred.
Bye, Fred.
Hi, Fred.
I might just hear the name.
Oh, is this Mr. Moore, maybe?
That's correct.
Yeah.
Great, we'll go on the record in the state of Wisconsin versus Creed Moore. It's 25 CF 2622 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Creed Moore appears in custody via Zoom. I believe he is behind his closed door. I see he has representation through the state public defender already. Mr. Moore, can you hear me? Give me a thumbs up if you can hear me. Okay, Mr. Moore has indicated that he can hear me. Mr. Moore, you've been charged with 1 count of solicitation of first-degree intentional homicide with a repeater enhancement. I will waive the reading of the complaint on his behalf. And Mr. Moore, if you were out of custody, would the address 810 Vernon Ave in Madison be correct? Give me a thumbs up if that's the case. He has shook his head. I'm afraid, bailiff, I can't hear you.
I think he's trying to unmute him.
Yes, sir. Okay, thank you. Then I think we're good.
And I just want to clarify one point. I know he was eligible for a public defender on some underlying stuff. Does he need to give them a call to get evaluated on this case, or is he all good?
He should be fine. I already have the eligibility paperwork here.
Great. So Mr. Moy, they're going to get you a lawyer in this case. It'd probably be the same lawyer you already have. We'll make a finding of probable cause. I think he's sitting on $1 million cash bail on a first degree intentional homicide case.
That's correct.
I also think he is on a DOC hold and they're pursuing revocation, or he's actually been revoked, according to the booking sheet. What's the state's position on bail?
I'm asking for a $1 million cash bond in this case. I'm asking that the defendant have no contact with Fiona C, and that the defendant not use or possess any dangerous weapons as that's defined by the Wisconsin statutes. Commissioners, you noted Mr. Moore is currently on a $1 million cash bond in the 25 CF87 case, where he's charged with, first degree intentional homicide, along with armed robbery as party to a crime, along with possession of firearm by a felon. Here, Mr. Moore was previously convicted in 2024 of second degree recklessly endangering safety. And then furthermore, right, so that's, which I believe is relevant given the Act 3 analysis of this case. Here, while he's on bond for allegedly killing somebody, he is in the jail where he's soliciting 2 other inmates to kill his ex-girlfriend. By the way, he's a witness, that girlfriend is a witness in the pending homicide case. This is an incredibly egregious act to subvert the judicial process if the allegations in the criminal complaint are true. It shows me that Mr. Moore is literally willing to try to get someone killed in order to make sure that his homicide case goes away. Given that and the fact that we are talking about an Act 3 eligible offense, I think that $1 million is absolutely appropriate.
Right, Attorney Sheehan.
Thank you, Your Honor. The allegations are, to my understanding, substantiated by confidential informants that are also inmates. I don't think the case is as rock solid as alleged. Regardless, he is currently sitting on $1 million cash bail. I don't think another million is appropriate or necessary to protect the public or ensure justice is served. I would ask for $100,000.
All right, and any response from the state?
I think $1 million is absolutely appropriate. I've never heard, you don't hear every day, someone trying to kill a witness or solicit the killing of a witness while they're on bond for a homicide case. It's incredibly serious. And I think that merits us indicating to Mr. Moore that this is a substantial case, can't be tolerated. I think when we consider Act 3 eligibility and the fact that he's taking substantial steps in order to subvert the judicial process, the fact-finding process, the truth-finding process, I think $1 million is more than warranted.
All right, well, regardless of what the bail is, it seems academic. He's being revoked on a felony. He's on $1 million bail. He hasn't been able to post that bail. The amount of bail obviously doesn't serve as a deterrent to avoid committing crimes if it's never even posted. That said, as the state notes, it's an extremely serious charge. It really strikes at the heart of the justice system that somebody's charged with something, and rather having a fair trial is not just trying to rig the system in his favor, but eliminate witnesses from the jail. The strength is going to play out. Ultimately, yes, they are confidential informants. There is a reference, I don't know that I put a ton of weight on it because it is pretty much conclusory about some audio recordings that corroborate that. But there's also some writings that are found that corroborate one of the confidential informants, and some other things that they found in Mr. Moore's belongings that suggest a desire to have somebody killed. And I don't pretend to understand all of the slang language, but certainly one reasonable reading of the paragraph just before the repeaters alleged at the tail end of the complaint is he wants somebody to kill that particular person. There may be other arguments as to what that handwritten note means that the defendant had, but it's all extremely concerning. I don't know whether setting a bail here at $100,000 or $1 million does all that much with Mr. Moore's current situation or sending any sort of deterrent effect. But I think the public needs to know that this sort of thing absolutely cannot be tolerated. He's not any better bail risk than he was when there was $1 million bail. And this is all great evidence for his homicide charge, which things aren't getting better for him there because of this information. I'm going to set $1 million cash bail, order no contact, direct or indirect, with Fiona C. that he not use or possess any dangerous weapons, as that term is defined by the state statutes. Is he past arraignment in that other case?
Yes.
Okay, I assume you want a timely prelim in the next.
Please,
10 days.
thank you.
All right, we'll get that set and we'll be adjourned.
Next up is Devin Hughes.
We'll go on the record in the state of Wisconsin versus Devin Hughes. It's 25 CF 2621 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Hughes appears in person in custody alongside Attorney Connor Sheehan. We have a copy of the complaint. We'll waive its formal reading. The address is correct. Let me check his eligibility. He is eligible for representation from the Office of the State Public Defender.
Great. I'll make findings of probable cause and are not guilty pleas to the misdemeanor charges. I believe we have a victim who wanted to make a statement. Yeah, I think they're on Zoom. So if the victim in the Hughes case wants to make a statement, just identify yourself and then you can let us know what your thoughts are.
Hello, hello, Your Honor. My name is Tori Agasquay. Thank you for hearing me today. I do want to start by saying that I wish to have contact with Devin. He and I are currently in a relationship. We've been together for 7+ years now, and I'm his support system, and I need him, out here. And this whole thing was really blown out of proportion insanely. We were out celebrating our anniversary over the weekend, and I got pretty drunk, and then I don't really remember why, but I was screaming my head off and I was falling around. And at the time when the officers came up, he was helping me up off the ground after I scraped my knee and ripped my tights. I was really mad about that. And they they came up out of nowhere and just bear hugged him. And neither of us knew that that was the police at the time. So I'm guessing that's where they got resisting from, but they really didn't identify themselves or anything. So that's where that came from. But all in all, it's really just a huge misunderstanding. We've never been in this position before, and he's been, off of, what's it called? Probation for a while. He hasn't been getting in trouble at all. His rides to and from his job interviews he has this week that I'm hoping that he can start. We have no means of getting a cash bail at all. In the past, I've been the only one who has been helping him and supporting him with that. I've had to take out a loan for it. I just have no extra money to do a bail. So I wish that he could get a signature bond. Again, this was just a simple misunderstanding, and we were out having a good time, and then the police coming up made everything extremely worse, and tensions were already high as I was, yelling a lot, and I was under the influence. So I regret the way I acted that night even. So, but I want definitely want contact with him. I've never felt unsafe with him or anything like that. You know, he's my man. We've been together for a long time, and it would really just would do us both good for him to be able to get out on a signature bond and have contact with me for sure. I give him rides to, you know, his job interviews, and he helps me with everything. And I just, yeah.
Okay, thank you. I believe you gave the last name, and is that AGAS hyphen KWE?
Correct, Your Honor.
Okay, I just wanted to make sure our court reporter had that down accurately. What's the state's position on bail?
I'm requesting a $1,500 cash bond in this case. I'm asking that the defendant have no contact, direct or indirect, with Toriana A-K. I don't know if you spelled it already. For the record, I believe the spelling of her first name is Toriona. I would also ask that the defendant be banned from her residence, her place of employment, or any location that she temporarily occupies. I would also ask that the defendant be banned from the state and Langdon ban area that we have in our ban map, and that the defendant not use or possess any alcohol. I'll note that Mr. Hughes does have bench warrants issued against him in the past, though I'll note that they're not within the past 4 years, though they're consistent enough that I think I should at least mention them. Looks like he has a bench warrant issued on February 12th, 2020 out of county. That was in 19 CM 1277. And then here in Dane County, he has bench warrants issued on January 29th, 2020, January 7th, 2020, November 12th, 2019, November 6th, 2019, October 15th, 2019, and August 12th of 2019. In this case, Mr. Hughes is physically resisting an officer and attempted to grab his taser after the officer intervened in what was reported as an ongoing physical domestic incident between both Mr. Hughes and the alleged victim in this case. And in addition to grabbing the taser, the defendant also grabbed and nearly removed the officer's tactical vest. He proceeded to attempt to flee on foot before the taser was successfully deployed, and then he continued his physical resistance on the ground until detained. He's charged as a repeater because he has a previous conviction of battery to law enforcement officer. So he's continuing in this pattern of behavior. And as far as substantiating the no contact, I'll note that I don't believe that there's been any cases charged between Mr. Hughes and Toriana, though my understanding is that she reported at least uncharged acts of domestic violence between the pair to law enforcement. And I'll also note that the domestic violence incident that was necessitated police to come to the scene in the first place is pretty disturbing. The defendant is loudly yelling at his girlfriend, straddling her, at one point dragging her across the ground before law enforcement's arrival. I understand, if Toriana disputes that now, but I think it's also worth noting that the level of screaming in this case was pretty substantial. I think I think there was a bystander witness who indicated they could hear the screaming. She described it looking like a scramble. I think that made it off into the criminal complaint. She said that the female was, quote, yelling, "Get off," end quote, and saying, she told me that the male responded to the female saying, quote, "Shut the F up," end quote, and that the female continued to yell, the male continued to yell profanities. So I think that, listen, if this was a less serious domestic incident, maybe we can talk about no acts or threats of violence. But I think right now, the fact of the matter is that you have a high level of violence here. And I think that a no contact is important.
All right, and Attorney Sheehan.
One moment, please. Thank you for your patience. Couple of things. First, even by the officer's description, I believe that they approached Mr. Hughes from behind. At least initially, it was just a pure reaction to being, in his own words, jumped. He had recently experienced a robbery of his own person. It's a physical reaction. I'm not saying it excuses the behavior, but I think it gives it appropriate context. As far as bringing in the past bench warrants, again, it's 4 or 5 years old. They all happened within seemingly 4 months of each other, I believe, if my math is right, 5 years ago. He also just finished probation. So I would go against the idea that there's a demonstrated history of missed appearances. Maybe if we were talking in 2021, I would have no argument. But as far as his just having completed probation with no missed appearances, I don't think that argument stands. The reporting of uncharged acts, that means nothing. I'm sorry. There's a level of belief that everyone has to take when making these arguments. That is not, I would object to that being considered at all. Ban from what was the physical ban? I apologize.
The state and Langdon ban area. And then any place of her employment, any place that she resides, any place she temporarily occupies.
Thank you. I don't see how these are, just putting aside for one moment the issues with the alleged victim in this case, I don't see how this is a specifically physically associated with that area. That doesn't make sense to me, so I would object to that non-monetary condition. It sounds like not an exceedingly violent issue. It sounds like they were very drunk. Like dragging someone because they're non-responsive, screaming at someone to get up or to shut the F up. It sounds like drunken behavior. I'm not saying again that this is good or pro-social conduct, but I don't think it demonstrates a level of violence that demands we separate a relationship, both halves of which want contact. If the statutes demand that we listen to and consider the wishes of victims, there we go, we have it. Mr. Hughes cannot afford $1,500. He cannot. One moment. Mr. Hughes does not have any cash to pay cash bail. He has orientation for a new position tomorrow morning. I'm asking for a signature bond. I would object again to the no contact and the physical bans involving the alleged victim in this case. And that's all.
All right. Well, I don't know how I square the victim's version of what happened with what allegedly third-party uninterested people said they saw, and law enforcement's statements where they say they clearly identified themselves, and even if they hadn't, certainly at some point during the struggle for the taser, it would have been abundantly clear as to who they were. This is a pretty aggravated resisting, and so that's concerning from an appearance perspective for somebody who's had an extensive history of failures to appear, albeit 5 or 6 years ago, there were a lot of them. The alleged behavior is, to me, not consistent with a signature bond. I'm going to set $1,000 cash bail. I'm going to order a no acts or threats of violence towards Toriana AK. I don't really put a weight on other supposed disclosures to law enforcement, but the state didn't think that there was probable cause to charge out. I'll defer to her wishes. Given that, I'm not going to order the address ban from her residence or place of employment. I agree with Attorney Sheehan. I'm not sure that State and Langdon is really the impetus for any of this. Certainly, there's sometimes behavior where somebody's having drunken contact, abusive contact with just complete strangers. That's not what happened here. I'm not sure that's necessary. I'm not going to order that. I am going to order the no alcohol. It says that Mr. Hughes was drinking, and maybe that played a significant role in everything that allegedly happened here. Obviously, that's all gonna have to play out at a trial. What's his position on time limits for a preliminary hearing?
We will not waive them. We would like a timely prelim.
Okay, we are adjourned. Thank you.
Next up is Kyle Nelson for forfeiture.
Oh. We'll go on the record in the County of Dane versus Kyle Nelson. It's 25 FO 2216 appearances.
The county appears by Assistant District Attorney Thomas Valerio. The defendant, Mr. Kyle A. Nelson, appears via Zoom in custody without counsel.
Right, and Mr. Nelson, some good news. They're not charging you with any new crimes. They've charged you with county disorderly conduct. That's non-criminal. It's more like a speeding ticket. Looks like there's a DOC hold that's still in place. I don't have any authority to do anything with that. But the county's gonna have an offer. If you wanna accept that offer, then you can just be done with the case. If you don't, that's fine as well. It's not gonna affect your release. But again, the DOC holds a separate issue that won't be addressed today. I'll talk to your agent about that.
Okay.
Is the 6317 Ford Street, Monona address the best place to get mail?
Yeah.
Okay, and Attorney Valerio, what's the county's offer?
County's offer is court costs only.
That's gonna be $114.50. If you want to accept that, you just need to make a payment of that within the next 60 days or work out a payment plan if you need more time. Did you want to accept that offer? Do you want to contest the charges?
What's up?
All right, I'll judge you guilty of county disorderly conduct, or you pay the court costs. They'll give you some information about making the payment and we'll be adjourned.
Next up is Joseph Haynes.
Right, we'll go on the record in the state of Wisconsin versus Joseph Haynes. It's 25 CM 2760 appearances.
State appears by Assistant District Attorney Thomas Valerio.
Mr. Haynes appears in person in custody alongside Attorney Connor Sheehan. He is not eligible for representation through the state public defenders. The address in the complaint is not accurate. I have an updated address whenever you're ready.
Go ahead.
It is 5577 Odana Road, number 301 in Madison, zip code 53719.
Thank you.
Oh, and I apologize. We have the complaint. We'll waive its reading.
All right, and Mr. Haynes, I think they gave you the public defender information. Sounds like you make too much money to be eligible. If you can't hire an attorney on your own, you can always reapply if you thought they did the math wrong, or you could apply for a county attorney. That's the middle option, all right? We'll make a finding of probable cause for the charges, enter not guilty pleas. And then I believe we have a victim who wanted to make a statement. I think they're on Zoom, but they would need to unmute and then just identify yourself first, and then you can let us know what you're asking the court to order.
Hi, my name is Addison Radcliffe, and I am asking for a cash bond as well as no contact directly or indirectly to me, the 5500 block of my apartment, because that's not his address, of Odana Road, as well as the 700 block of North High Point Road, which is my workplace. And then I'm also asking for no drugs and alcohol or weapons with pretrial monitoring, and then potentially ankle monitoring to ensure my safety if he were to be released. So that is what I'm asking for.
Okay, it looks like the name is spelled Addison, last name Radcliffe, Radcliffe. Is that right?
Radcliffe, correct.
Very good, thank you. I appreciate your information. And I think you made clear, but the Odana Road address is your address and you don't want him back there.
Yeah, correct. My landlord has actually issued like a no trespassing, which really ultimately waives his rights as a tenant.
Okay, then let's turn to the state attorney Valerio.
I have no objection to a signature bond in this case. I would ask that the defendant have no contact with Addison R., that he be banned from the 5500 block of Odana Road in Madison, Wisconsin, 53719, that he be banned from the 700 block of North High Ridge Road in Middleton, Wisconsin, 53717, that he not use or possess any alcohol, that he not use or possess any drugs or drug paraphernalia without a valid prescription, that he not use or possess any dangerous weapons as that's defined by the Wisconsin statutes. And then I would also be happy to adopt the victim's request of a ban from any place that they temporarily occupy as well.
Okay, any objection?
One moment, please.
I'm sorry, the second address, was that 700 block of North High Point or North High Ridge?
Hold on.
I
So,
had written High Point, but maybe I heard it wrong.
so what I have in my notes is North High Point Road. Addison, does that sound correct to you? North High
That
Point
is-
Road?
North High Point Road is correct.
Okay, thank you.
Thank you.
So no objection. We just want to ensure that Mr. Haynes can get his possessions from the apartment. So if he's allowed to do that through like via law enforcement, then that's fine. There just
Okay.
needs to be an opportunity afforded to him to get his possessions so that he can be done with this.
Well, the only way he'd be able to get the possessions if I adopt the no contacts and the address ban is with the presence of law enforcement. I can't guarantee that they're gonna go with him. Obviously, they're busy. He'd have to arrange a time
Of
that
course,
works for them. But there can't be any contact otherwise.
understood. And no objection.
All right. And Attorney Valerio, I don't know that we had the benefit of a PSA. Is there a prior history or anything that is relevant?
But well, let me just double check one more thing. Not that I'm aware of. So at least in the state of Wisconsin, I can't see that Mr. Haynes has been charged with anything. So no missed court appearances for that reason. So that's why I'm asking for the signature one.
All right. Well, I certainly appreciate the victim's input. I simply can't just order cash bail because it's asked for by a victim. I also don't necessarily have to allow contact just because a victim asked for it. I think it is valuable information. I need to take it into consideration in the total picture. The information I have is that there's no prior criminal history, no failure to appear. Serious stuff, but obviously we're not talking about felony level stuff. I've got an experienced prosecutor and defense who have a stipulation. I'm supposed to give deference to that. So I'm not gonna order the cash bail and the pretrial services. But warn Mr. Haynes, for somebody who apparently doesn't have contact with the criminal justice system, you violate conditions of bail and pretty soon you can have cash bail and pretrial services, because then you'll have shown the court that you are a risk to not appear because you're violating conditions of bail, potentially a risk to the victim or other members of the public. So it is vitally important that you follow each and every one of the conditions that I'm going to order as a condition of your signature bond. That one is a no contact direct or indirect with Addison R. We've already talked about the only way you can get your things is with the presence of law enforcement. So I believe that would be contacting the City of Madison Police Department. Any questions or clarifications about that? Because I've certainly seen plenty of instances where people end up there and they say, I was only getting my things and I didn't understand. So let's clarify down. All right, you understand what'll happen if you violate that. You'll be arrested, charged with bail jumping, and I bet you the state's going to be asking for cash bail at that point, and that might be persuasive. I'll order a ban from the 5500 block of Odana Road, a ban from the 700 block of North High Point Road, that you not possess or consume alcohol, that you not use or possess any dangerous weapons, as that term is defined by the state statutes, not use or possess any controlled substances or drug paraphernalia without a valid prescription. And then I think there was a request at the end for any other premises that Addison R is temporarily occupying, you can't be there. What that means is if you were to run into them inadvertently in out in public at the grocery store, you gotta go the other way. You stay there, then you're in danger of being in violation of your bond conditions. That's what that, any other place they're temporarily occupying means. Understood? All right. If there's nothing further, we'll be adjourned. Thank you.
Was there a better address?
Oh, thank you.
So,
Is there another place you can get mail from the court for court notices?
yes, thank you. If you can just tell the clerk now. What's the other?
about Hart, he was at Fitchburg,
Okay, well,
Yeah.
we don't know your cousin, so that's not gonna work, but
Okay.
what you can do is, and you didn't qualify, so you can write the court and tell them the address, put your case number on that. And if you've got a cell phone, I would highly suggest that you sign up for text message reminders, so they're gonna have you sign some paperwork, get your bond, your next court date. You can ask them to get signed up for text message reminders. If you've already retained an attorney, you can let the attorney know and they can update the court, but it's your responsibility to make sure that we have a good mailing address going forward so you don't miss future court dates and get a warrant.
Absolutely.
I don't have that. Okay, we are adjourned.
George Pearson is next, appearing by Zoom.
All right. Hold on.
All right, we'll go on the record in the state of Wisconsin versus George Pearson. It's 25 CM 2752 appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Mr. Pearson, my name is Connor Sheehan. I'm a staff attorney at the State Public Defenders. If you can hear me, please give me a thumbs up.
All right, saw a thumbs up.
You've indicated that you do not want me to represent you during that initial appearance. Is that correct? Can I get a thumbs up? Or would you like me to represent you?
Mr. Pearson, Attorney Sheehan's an attorney with the Public Defender's Office. He's willing to represent you today. That doesn't mean you're entitled to have him or any public defender going forward. Would you like him to assist you today?
I would like him to represent me.
Okay, happy to. Thank you.
Yeah, so once we.
Do you have a copy of the complaint?
Yes,
Is the address on Milwaukee Street correct?
yes.
Okay, thank you. We'll waive its formal reading. The address is correct, and I am unable to say whether or not he's eligible at this point. So I will have someone from my office revisit him tomorrow.
All right, and so, Mr. Pearson, I'm just gonna talk about your right to an attorney. Obviously, you have the right to an attorney. You could hire one on your own after today if you're able. If you're not, you could reapply with the Public Defender's Office. So it sounds like they haven't maybe done the whole evaluation. You just told them you weren't interested later on, so if you change your mind, give them a call. We'll make sure you get their information. I'll make a finding of probable cause and are not guilty pleas to the charges. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant have no contact with Carolyn P. For the record, her first name is spelled Carolyn, as in Nancy. I would ask also that the defendant be banned from the 6500 block of Milwaukee Street, Madison, 53714. The victim in this case is in support of the bail recommendations.
Right, and any
Miss-
issue?
Thank you. Mr. Pearson, do you understand the conditions the state asked for? They want to prevent you from speaking to Carolyn P. That would be no contact, direct or indirect. They also want to ban you physically from going to the 6500 block on Milwaukee Street in Madison. That would mean we'd need to get a new address, so you could not go back there. Do you understand?
Yes,
Okay, do you want me to object to those conditions on your behalf, or are you willing to accept them?
I'm willing to accept them.
Okay, you understand that if you violate either of those, you will be subject to charges of bail jumping.
Yes.
Okay, no objection.
All right, I'll order a signature bond conditional be a no contact direct or indirect with Carolyn P. A ban from the 6500 block of Milwaukee Street in Madison. Mr. Pearson, is there a better address that we could use for sending court notices to you?
I'm sorry.
Sorry, that's me. I haven't talked to very many people in a while.
Okay, well, if you're not sure right now, that's fine. He's gonna get his next court
I
date
can-
today. So when you figure out where you want your mail sent, just write the court, put your case number on that, let them know where you want mail sent. If you have a lawyer at that point, let them know and they can update the court. And you could also sign up for text message reminders just to make sure you don't miss any future court dates until you got a more stable address. And
yes.
go ahead.
No, yes, Your Honor.
And then briefly, if you need to get any items from the residents, the only way you can do that is being in the presence of law enforcement. You'd have to contact the City of Madison Police Department in order to do that. Don't show up there without law enforcement presence. You're going to be violating your bail. You'll get in trouble, get arrested, be back here, and then the state might be asking for cash bail. All right.
Very quickly, Mr. Pearson, it's Attorney Sheehan again. If you want to pursue representation through the Office of the State Public Defender, if you have questions about your case, please come to my office or call, okay?
Yes.
We'll make
Okay.
sure he gets the public defender info in case he changes his mind.
Great, thank you.
All right, if there's nothing else, we'll be adjourned.
Next up is Senator Harris. Harris.
Oh, sorry. Is this address correct? Arlington.
Right, we'll go on the record in the state of Wisconsin versus Cedric Harris is 25 CT 770 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Harris appears in person in custody alongside Attorney Connor Sheehan. He is eligible for representation through the Office of the State Public Defender. We have received a copy of the complaint and we will waive its formal reading. Thank you.
Right, I'll make findings of probable cause. We'll get not guilty, please entered.
I apologize. The address is correct.
Okay, super. Let me see, I don't think we had a PSA report. Nope.
No, Your Honor.
What's state's position on bail?
I have no objection to a signature bond. I would ask that Mr. Harris not operate a motor vehicle. It looks like during the commission of this offense, he was under conditions in a Rock County case to not operate a motor vehicle for an open OWI court. So that's why I'm asking for it here.
Right, any objections?
No, Your Honor.
Okay, we'll order a signature bond condition will be that you not operate a motor vehicle at all. Bond obviously can be reviewed and changed. If you get a valid license, you can always have your lawyer file a motion to review the bail. And then we'll be adjourned.
Good luck.
Yeah, I think you're gonna get released. I don't know that anything else.
What's up is very stupid.
Is address correct?
Right, we'll go on the record in the state of Wisconsin versus Darius NEWMAN. It's 25 CM 2751 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Darius Newman appears in person in custody alongside Attorney Connor Sheehan. He is not eligible for representation through the Office of the State Public Defender. We have received a copy of the complaint. The address is correct. We'll waive its formal reading.
Right, so they've given you the public defender info, and in case you need that, if you can't hire an attorney on your own after today, you can always reapply with them. The other option is you could apply for a county attorney. That's kind of the middle option. We'll make findings of probable cause and are not guilty pleas to the charges. There is a public safety assessment report. It recommends a signature bond. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant have no contact with Angel G and that he not use or possess any alcohol. Angel G is in support of the no contact.
Great. Any objections?
One moment, please. No objections. Wait, actually, one moment. No objections. Thank you.
Okay, and just to clarify, that isn't going to cause any issues with the address. You'll be able.
That's
to
what I was checking. They don't live together.
Okay. I'll order a signature bond. Condition will be a no contact direct or indirect with Angel G, and that you not possess or consume alcohol. And I think you're going to get released. We'll be adjourned. Good luck.
Next up is George STAISIL with Trigger by Zoom.
Go on the record in the state of Wisconsin versus George STAISIL. It's 25 CM 2756. We'll also call the County of Dane versus George STAISIL 25 FO 2217. Appearances.
The state and the county appears by Assistant District Attorney Thomas Valerio. I appear in person.
George STAISIL appears remotely over Zoom. He appears to be looking through the food slot in his cell. Mr. STAISIL, can you give me a thumbs up if you can hear me? Wonderful. Do you have a copy of the complaint in your criminal case? Seems so. Okay. Is the address of Rethke Ave correct? Give me a thumbs up if that's the case. Okay, we will waive its formal reading.
Okay, I'll make a finding of probable cause in the criminal case, enter not guilty pleas on his behalf. We'll just enter a not guilty plea in the forfeiture, and that'll track along with the criminal case. There's a PSA report. It recommends a signature bond. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant exhibit no acts or threats of violence towards Whitney J.W., and that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription. Just so I'm 950 compliant, Commissioner, it looks the victim in this case is Mr. STAISIL's case manager. The victim indicated that it's her. She would love for him to be ordered to comply with mental health and AODA treatment, but we told her it's probably not enforceable to do that as a bail condition, and she understands that. But I thought I'd mention it to be compliant.
Right. I appreciate that. That's something that's maybe more appropriate if there's a disposition. I certainly wouldn't ordinarily order that. Any objection from the defense?
Yes, Your Honor. I would object to the no controlled substances condition. It's duplicative. It's already illegal to use drugs without a valid prescription. And I would just want to make very clear regarding the AODA treatment. Pretrial services does not, that is not AODA treatment, just to be clear. That's all.
All right. Well, I'll order a signature bond. I'll order no acts or threats of violence towards Whitney J.W. I think maybe I differ from other court commissioners who refuse to order that condition because it is a restatement of the law. Quite frankly, I haven't seen people charging a bail jump for no new crime and a bail jump for the controlled substances at the same time. I don't think that's happened in some time. I do think that there is some benefit in reminding the party that they cannot do that with a specific bail condition. So I'll order that they not use or possess controlled substances or drug paraphernalia without a valid prescription as well. And we'll be adjourned.
Next up is Alan PUSKARICH. All right.
Right. We'll go on the record in the state of Wisconsin versus Alan PUSKARICH, 25 CF 2623 appearances.
I'm sorry. What do you have the case number?
25 CF 2623 Alan PUSKARICH, PUSKARICH.
Got it. Thank you. The state appears by Assistant District Attorney Thomas Valerio.
Alan PUSKARICH appears in person in custody alongside Attorney Connor Sheehan. We have a copy of the complaint. The address is correct. We'll waive its formal reading. He is not eligible for representation through the state public defenders.
Okay, so sir, the deputy's giving you the public defender info. Sounds like you're not eligible. You can always reapply. You can hire an attorney on your own if you're able to. If you can't, there is a middle option to apply for a county appointed attorney. I'll make a finding of probable cause, and are not guilty pleas to the misdemeanor charges. State's position on bail.
Sorry. All right. I'm recommending a $500 cash bond in this case. I'm asking that the defendant not use or possess any drugs or drug paraphernalia without a valid prescription, and that he not operate a motor vehicle. I think the prevailing reason for why we're asking for cash bail is because this is Mr. Puskarich's third open case here in Dane County. And he's continually violating the conditions of his bond. Here, he's driving a car with a plate that doesn't match the car he's driving with. He also admits he's on felony bond. He isn't supposed to drive. Like he admits that he's not supposed to drive. And they find meth in the car that he's driving, and they find him in possession of drug paraphernalia. So he's violating specific conditions of bond. It's his third open case. It's still a felony case. Like it's a drug possession case ultimately. So I think that there should be modest cash.
Okay, and Attorney Sheehan.
Your Honor, Mr. Puskarich cannot afford the amount prescribed. He can afford $250. That is an amount he can actually pay. It is a serious.
Couldn't hear the amount.
I apologize. $250. That is an amount that he can actually pay. It is a condition of release, and we would ask that you order $250 cash bail.
I'll stipulate to the 250.
All right. Well, I think it's reasonable. I was probably going to adopt that without the stipulation. I just don't see enough of a difference between the two amounts. I'll set $250 cash bail. Again, I'll order that you not operate a motor vehicle at all, and that you not use or possess controlled substances or drug paraphernalia out of valid prescription. And the bail doesn't usually get better if you pick up new cases once you've got cash bail, Mr. Puskarich. So try to avoid that happening. Did he want a prelim in the next 20 days?
We'll waive the time limits. Thank you.
Okay, we are adjourned.
Next up is Frank Reed.
We'll go on the record in the state of Wisconsin versus Frank Reed Jr. It's 25 CM 2764 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Mr. Reed appears in person in custody alongside Attorney Connor Sheehan. He is eligible for state public defender representation. We've received a copy of the complaint. We'll waive its formal reading. The address is correct.
Okay. So I think there's a contempt of court, maybe that's a hold on Mr. Reed. That's a separate issue. You're gonna have to address that with the family court. Other than that, I'm not seeing anything holding you. I'll make a finding of probable cause and are not guilty plea to the charge. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant have no contact with Ariana J. For the record, you might have it already, Commissioner, but the first name is spelled Ayreona.
Any objections?
Your Honor, we have to object. The two do live together, and without the input of the alleged victim, we're going to ask that you not order the no contact.
Okay, and I don't know if we had a 72-hour no contact. I guess I don't remember seeing that in the case, but maybe I overlooked it.
Sure, looking at the, there indicates there are $70 time this way.
Any additional statement from the state?
Looks like we haven't heard back from the victim yet as pertains to the bail conditions. So right now, yeah, it looks like the victim called back saying that they would later provide their input regarding the bail recommendations. I don't have anything up or down from Ariana J as to whether or not she's in support of the bail recommendations.
Okay, and is there a prior history or anything that you're aware of?
No, not that I'm aware of.
All right, I'm just taking a closer look at everything here.
Your Honor, I will say that his other pending charge is a DPU disposition. So I doubt his history is very long.
I believe the case we're referring to is 24 CM 208. That's what Judge refers. This will be assigned to the same branch.
That's correct. Thank you.
All right, well, I think the best information I have as to the victim's wishes are the fact that they waived the 72-hour no contact. I mean, I think I can infer that at least at that particular point in time, they weren't worried about whether Mr. Reed has contact with them going forward. And certainly it sounds like they had the opportunity to provide input to the DA's office and haven't. That said, if their position changes at any point in time, they're certainly free to request the DA's office to, file a motion to modify the bail conditions. And there's apparently no prior history here. He's ultimately just charged with the DCL. Order the signature bond and order a no acts or threats of violence towards Ariana J. And we'll be adjourned.
Thank you.
Our bailiff is currently standing by with Henry Brown. I've been informed by the bailiff that Henry Brown is not going to participate in any way, shape, or form. The bailiff is going to keep the food slot closed at this point in time due to safety concerns.
Okay.
Mr. Brown has a couple of holds out of Jefferson County. Does this seem like something that he's gonna change his mind about in a day or two?
That was not the impression that I received.
All right, well, maybe we will take care of the hearing. All right.
Next up is Henry Brown, hearing by Zoom.
All right, we'll go on the record in the state of Wisconsin versus Henry Brown. It's 25 CM 2759 appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Henry Brown is objected to is not participating. I object to this going forward. He has a right to participate. I don't know. I haven't spoken to him, so I would ask that the hearing be set over.
All right.
He has holds out of
And
Jefferson County
he's got
anyway.
body only warrants out of Jefferson County.
It's not like his
So
freedom is
it's not
imminent.
the thing that's making the difference between whether he remains in custody or not.
Mr. I guess I would note, I know it's a long afternoon, but Mr. Brown is in SEG nearby, nearby cell. If Attorney Shane wanted to go visit him personally, he certainly could.
Sure. We can wait until he goes last and I can do the rest. Is that okay?
Well, let me check with the bailiffs because they have quite a bit of coordination that they have to do with things. If we were to do that, they might want you to go now. And I'm not going to give you any pushback. If you want to try and talk to them, that's certainly appropriate.
Okay.
So,
Mr. Brown, would you like to participate in today's hearing?
and I think he's muted. I see a thumbs up.
Okay. Bailiff, I need you to unmute.
I don't know if the deputy can unmute briefly, so
I need to hear from
Attorney
Mr.
Sheehan
Brown.
Can get info from Mr. Brown.
Environment segregation right now is incredibly noisy, and that you're not gonna be able to hear anything over the intercom if you have use. If you'd like to go down and speak to him, we can facilitate that.
That might be
Sure,
the best
let's
option
do it.
now. We'll take a brief pause. Is there anybody else down in SEG now that Attorney?
And
There is-
Attorney Sheehan.
Sure.
All right, I don't remember if I called the case, so.
You did.
Let's call the state of Wisconsin versus Henry Lee Brown, 25 CM 2759, again, and get the appearances.
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Mr. Brown appears remotely and by Attorney Connor Sheehan. He has received a copy of the complaint. The address is correct. I'm going to waive its formal reading. The state has already named its recommendation to me off the record. If you could reiterate it on the record.
Sure. I'm recommending a signature bond and condition that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription.
Mr. Brown is not appearing on screen. I went to go speak to him in segregation. He has no objection to those conditions.
All right, I'll order a signature bond with the condition that you not use or possess controlled substances or drug paraphernalia without a valid prescription. He's sitting on some body only holds out of Jefferson County, so he's gonna have to sort those out with them. Was he eligible for a public defender, if you know?
Yes, he is.
Okay, very good. So they'll get you a lawyer.
You have to be kind of the drop close. It's the 6:15 Washington.
That's correct.
All right, we are adjourned.
Thank you.
You're welcome.
Next up is Valerie Zaboter for forfeiture.
Great, we'll go on the record, in the County of Dane versus Valerie Zabotar, 25 FO 2218 appearances.
County appears by Assistant District Attorney Thomas Valerio. The defendant, Miss Valerie L. Zabotar, appears in person in custody without counsel.
Right, and ma'am, they've given you a forfeiture complaint that alleges county obstructing resisting an officer. What that means is a non-criminal charge. It's more like a speeding ticket as far as severity. It's not going to hold you in custody after today. I don't think anything else is holding you, so I think you're going to get released. Is the address on the complaint a good address for mailing purposes? Okay, very good. So because it's a non-criminal matter, they're actually going to have an offer, or we'll hear what that is.
Court costs only.
So it'd be $114.50. It's not like bail. You don't have to pay it up front, but you would have to pay it either in the next 60 days or work out a payment plan with the clerk's office if you need more time to pay. Did you want to accept their offer? All right, I see a thumbs up. I'll judge you guilty of the charge. Or you pay the court costs. They'll give you some info about making the payment and you'll get processed and released yet today sometime.
Thank you.
Yep, you're welcome.
Next up is Shantavia Dance.
Go on the record in the state of Wisconsin versus Shantavia Dams. It's 25 CM 2749 and 22 CF 2534 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Ms. Dams appears in person in custody alongside Attorney Connor Sheehan. She is eligible for state public defender representation. We've received a copy of the complaints. Actually, let me make sure she has both.
So she probably just has one.
Right.
So the misdemeanor, BC and criminal damage is the new case. The other one's a return on warrant.
Yes, thank you. She has a copy of the new complaint. We'll waive its formal reading. The address on it is correct.
Okay, I'll make findings of probable cause in the new case, enter not guilty pleas. State's position on bail in each of the cases.
Sorry, 1 second. Sorry, 1 second. All right. I have no objection to you reinstating the signature bond in the 22 CF 2534 case. I would ask that you keep the non-monetary conditions the same. And then in 25 CF 2749, I have no objection to a signature bond there. I'm asking that the defendant have no contact with Raquel G or Syed J. Syed's first name is spelled S-Y-E-D. I would also ask that the defendant be banned from the Boulevard Lanes bowling alley. The victim, Raquel G, is in support of the no contact, and Syed J wishes to have contact with Miss Dams. Hold on. I'm actually okay with us just amending so no contact with Raquel G because she's in support of that, and then no acts or threats of violence with Syed J. I would still ask for the ban from the Boulevard Lanes in the new case. All right, that's it. Thank you.
All right, any issues with that?
No objections, Your Honor.
Okay, order a signature bond, or reinstate the signature bond in the felony case with the prior conditions. Order a signature bond in the new case, ban from Boulevard Lanes, no extra threats of violence towards Saeed J, and a no contact director and direct with Rachel G. And we'll be adjourned.
Good luck.
Next up is Anna Dulce, appearing by Zoom.
Great, we'll go on the record in the state of Wisconsin versus Anna Dulce. It's 25 CM 1455, 25 CM 1461, 25 CM 1465, 25 CM 1643, 25 CM 1714, and 25 CM 1720. Those are all return on warrants. Bail's already been addressed at an initial appearance. We also have the County of Dane versus Anna Dulce, 25 FO 2219. Could I get the appearances?
The state appears by Assistant District Attorney Thomas Valerio. I appear in person.
Ms. Dulce, can you give me a thumbs up if you can hear me? Great. Do you mind if I represent you during this hearing today? Is that okay with you? If it is, give me a thumbs up. Great. So I am going to represent Ms. Dulce. She is eligible for she does have representation. I understand that it's an appointment through your Office of the State Public Defender. She is marked as eligible regardless. The complaints, obviously, we're addressing bail, so her possession number not is not relevant. Ms. Dulce, the address on file we have is 1309 South Thompson. Is that correct? Yes. Okay, great.
All right, and I assume they'll appoint the same attorney, Ms. Dulce, but give them a call. We'll make sure you get the public defender info, but they're going to get you a lawyer for after today. We'll just enter a not guilty plea on the forfeiture case. It's a non-criminal that can track along with the criminal cases. And then what's the state's position on bail in each of the cases?
I'm recommending a $250 cash bond in each of the cases. When I'm shuffling through all of them, they all appear to be property related, though there are some en bloc abandoned vehicle cases. Those are still misdemeanors. So here it looks like Ms. Dulce had her initial appearance on January 2nd, 2025. And then in August of this year, she had her status conference, first one right after the initial appearance, and a bench warrant was issued. I tried to find her, tried to see what, okay, yeah, the bench warrant was issued on August 25th, 2025, as I mentioned. It doesn't look like she has any other bench warrants in Dane County. And I think the basis for why I'm asking for cash is because she was in warrant status for several months, and she was on warrant status in several cases. I recognize that, you know, these cases played out over the course of only a few days, Well, some of them did. Others, like the 25 CM 1643 case, happened in July of 2025. The 25 CM 1720 case happened in July 15th of this year. So I think when I'm looking at this, we're looking at someone who has several cases that are charged against them. They're each have different incident dates, and she was in warrant status for a significant period of time. I recognize a lot of these are property crime cases. I'm treating them that way because I'm only requesting a modest amount of cash. But I think when we add them up, I think, speaks to the fact that she was in warrant status for a significant period of time on several cases. I think that modest amount of cash throughout each of the cases is appropriate.
Great. And Attorney Sheehan.
Respectfully, it's not a modest amount of cash. It's $1,500 is what he's asking for. I appreciate the fact that Ms. Dulce was in warrant status for several months. I don't think that's uncommon. I'm not saying it's necessarily defensible or acceptable, but it's not uncommon for someone who is clearly indigent and clearly has demonstrable mental health issues. Even if these all 6 may not have happened over the 1 or 2 days, it still happened within a few weeks of each other. And I just, these aren't the crimes of the century. And to order Ms. Dulce to pay $1,500 is to order her to remain in custody. So I would ask Your Honor to award signature bonds.
All right. So back on July 30th, the court essentially ordered $800 cash bail, total between 2 cases. It was $400 per case. Those ultimately got modified to signature bonds. She's not in a better bail situation than she was when the court originally thought cash bail was warranted. It is significant to me the amount of time she's been out. At some point you realize, hey, there must be something going on. These cases just don't go away. It's not like she got picked up a week later. There's a county obstructing, resisting forfeiture. I don't know that I have the details surrounding. Actually, I do have the details surrounding that. There's a PC affidavit. So it looks like they found her hiding underneath some furniture and she didn't come out right away. Not the worst obstructing in the world, but not really all that consistent with somebody who is going to voluntarily turn themselves in. I agree, these are not the crimes of the century. It does add up pretty quickly. I'm willing to set it a little bit less, but I'm not going to do less than $200 a case. I'll order that. All the prior non-monetary conditions will remain. So $1,200 by my math would be the total bail. And we'll be adjourned.
Next up is Kirby Donini.
Go on the record in the state of Wisconsin versus Kirby Donini. That's 25 CF 2620. That's a new case. We also have return on warrants in 25 CM 339 and 25 CM 777. Appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Kirby Donini appears in person in custody and by her attorney Connor Sheehan. The address on the new complaint is correct. It's Columbus, Wisconsin. I think that's consistent throughout. She's received a copy of it. We'll waive its formal reading. I can confirm she is eligible for state public defender representation. I am her appointed attorney. And I believe that's all.
Right. I'll make findings of probable cause in the new case. Enter not guilty pleas to the misdemeanors. There's a public safety assessment. It recommends cash bail. State's position on bail in any cases.
I think my understanding is that she had signature bonds previously. Is that what you see, Commissioner?
No,
one of the cases, 25 CM 339, she was in fact given a signature bond, but later failed to appear for a hearing and a cash available warrant in the amount of $250 was issued, and he posted that, so she's at $250 bond in that case, and it's still on file.
Okay, so then I would ask that we keep the 250 on, and that was on the 339 case, right?
Yes.
So I ask that you keep the 250 there, and then I'd ask that you order an additional 250 in the 25 CM 777 case. Looks like there are bench warrants issued, obviously on October 27th, 2025. There's also bench warrants issued on September 16th, 2025, April 28th, 2025, and December 18th, 2020. Look, these are, again, property crimes, or one's a property crime, the other's a simple possession case. So obviously I'm asking for modest amounts in both cases. I think that amount's $500. It's consistent with the PSA recommendation.
New case for on 26.
Okay, hold on. All right, hold on. Didn't see that, sorry. And then in 25 CF 2620, I'm asking for a $1,500 cash bond, along with no contact with child victim 1, and a condition that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription. For the record, one second.
Is that LEK?
Yeah, so for the record, the initials for the child victim are LEK. So as I mentioned, there are several bench warrants issued against Ms. Donini. Now I'm looking at it. She's now charged with a child abuse case. That's certainly concerning. And in the child abuse case, she has serious drug issues. She's at a hotel with her 8-year-old son. There was probably apparent to law enforcement she spent a decent amount of time using, and I think the child's father came over, wanted to take the 8-year-old, but Ms. Donini wouldn't let him. Ultimately, cops got into the room. There was lots of drug paraphernalia in there, including a loaded syringe containing 0.35 milliliters of suspected heroin. So I think that now, given the fact that Ms. Donini is charged with that felony level drug possession case, along with the the child neglect case, there's also some obstructive and resistive behavior in the 2620 case. I think that cash bail is warranted.
And Attorney Sheehan?
One moment, please.
Sure.
Thank you. No objection to the additional $250 in the case ending in 777 and the reinstatement of non-monetary conditions. The $1,500 in the new case it's simply too much. It's prohibitively high. The no contact with her child, given the nature of the offense, we understand any amendment to that condition will be addressed further on. The obstructive and resistive behavior is hiding in a motel bathroom. It's not exactly violent. It's not exactly putting anyone in harm's way to any great degree. I would ask that the court order $500, not $1,500.
All right. Well, to clarify a couple of things, I don't think she's charged with child abuse, meaning physical abuse to a child. It's child neglect.
No specified harm.
Not to suggest it's good, but
Of course.
and the resistive obstructive behavior is a little more than her just hiding. She's allegedly putting her weight on the door and telling law enforcement she's going to come out, and then she doesn't. I've been doing this a long time, and you see all sorts of resistive obstructive behavior, or people lying about who they are, for people who have warrants, and it's more than just a coincidence. So it's certainly concerning from an appearance perspective. She's at the very top of the scale for new criminal activity and failure to appear. And a long time ago, one of the PSA reporters told me the breakdown of the number of people that actually end up at the very top, and it's a pretty small number. I think the state's request is pretty warranted. They could have asked for more cash than the 250 that's already on file. They could have actually asked to have that forfeited, but they haven't done that. So I'm not going to increase it in the 25 CM 339 case. It'll remain as ordered, 250 with the prior conditions. I will set $250 cash bail in the 25 CM 777 case. And I'll set $1,500 cash bail in the other case in order the no contact director and director of the LEK that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. And Ms. Danini, obviously, and I don't want any response because I don't want you to incriminate yourself. There's clearly underlying issues that need to be addressed so you can be there for your kid, and I hope you can do that. But for the time being, it's just an appropriate condition that you not have any contact. Well, we can get her a prelim in the next 10 days, though. If you let.
Please, thank you.
Okay. And I assume you'll get appointed to that one.
Yes.
You know the date,
Yes, November 25th, 1:30.
is that gonna work?
Thank you. Yes.
Okay. All right, we are adjourned.
All right, so next up is James Moe.
Go on the record, the state of Wisconsin versus James Moe. It's 25 CM 2750 appearances.
State appears by Assistant District Attorney Thomas Valerio.
James Moe appears in person in custody alongside Attorney Connor Sheehan. He is eligible for state public defender representation. He already has representation through my office, so I assume Attorney Kavanaugh will be appointed to this case as well. We've received a copy of the complaint. We'll waive its formal reading. The address is correct.
All right, and so right now, I think there's a couple of body only warrants, in some other cases, those are going back to the branch, so bail's not gonna be set until you have a hearing with the judge on those. There's also a contempt of court. That's a non-criminal matter that needs to be addressed. I'll make findings of probable cause for these charges and are not guilty pleas, state's position on bail.
All right, I'm requesting a $2,000 cash bond in this case. I'm asking that the defendant have no contact with Samantha A as a non-monetary condition. All right, so it looks like here in this case, Mr. Moe was in violation of the domestic violence injunction that's mentioned in the criminal complaint. But you know, it's also a bail condition in two of his pending cases right now where he's not supposed to have contact with this same victim. Mr. Moe also committed this offense while he was on bond when he, while he was absconding on a bench warrant when this occurred. And he also has a failure to appear in these cases on June 5th of 2025. And it also doesn't help that, you know, he's violating a domestic abuse injunction allegedly, right? That's a court order. I don't know what's going on with the contempt thing. It's still concerning. So I think that cash is necessary.
And to be clear, I think the contempt is one of the usual child support agency contempts for non-payment of child support, not a contempt of a family court order other than the non-payment of support.
Okay.
Attorney Sheehan.
One moment, please. Thank you. Regarding the no contact with Samantha, no objection to that at all. Regarding the failure to appear in these cases, that is typically how you get a bench warrant. I apologize. Thank you. So I apologize. Thank you. $2,000 is, again, it's prohibitively high. The sanction is for a failure to pay child support. He lacks funds. I would just ask that the court set it at 250 so that he can actually pursue release and pursue further employment so that he can pay the child support for which he's been sanctioned.
All right, and any response from the state?
I don't know. I think 250 is probably too low. I mean, here he's got a more serious failure to appear history than other folks in Mr. Mo's situation. I'll also note I failed to point out that there was a bench warrant issued in February 3rd of 2021 out of Winnebago County. That was case number 20 CM 33. And, you know, he doesn't, I think what's also concerning is that, you know, it's not, he's targeting someone he has specific bond conditions not to have contact with. We wouldn't be in this situation if we just stayed away from this person. So I don't know. He seems like a bigger bond risk than what a $250 cash bond would imply. So I think there needs to be more cash in that.
All right, well, I think he's out on the $500 cash bail in the two underlying cases. The 24 CM 155 and 25 CM 100. This is also an Act 3 eligible offense because the violation of the injunction. And I look at that much differently than if we were just talking about risk to not appear. I'm concerned about risk to appear, given the warrants, and there was a prior warrant for that. He's already posted cash bail and just generally thumbing his nose at the bail conditions and allegedly violating those repeatedly. But I can also set cash to protect the victim and make sure that there's compliance. And I guess at this point, I don't really have any confidence that Mr. Mo gets that when he's signing the bond, that's his promise. He's going to abide by certain conditions. This person does not want to have contact with you. I get it's difficult, the relationship and all of that. You just need to get the message. And I don't think you're going to get it with $250 cash bail. I think $2,000 is necessary and warranted given the history. I'll set that. I'll order a no contact director and direct with Samantha A. And we'll be adjourned.
Next up is Brent Schultz.
Mr. Schultz. We'll go on the record in the state of Wisconsin versus Brent Schultz. It's 25 CM 2754 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Brent Schultz appears in person in custody alongside Attorney Connor Sheehan. He is eligible for state public defender representation. And the address on Saturn Drive is correct.
Okay, I'll make findings of probable cause and are not guilty pleas to the charges. There's a public safety assessment report. It recommends a signature bond. State's position on bail.
I'm asking for a $750 cash bond in this case. I'm asking that the defendant be banned from any Walmart location and that he have no contact with Patrick C. or Christine S. It looks like this is so it looks like there were prior failures to appear on April 29, 2021, September 14, 2021, October 8, 2021, and November 9th of 2021. Looks like this is a case where I think law enforcement suspected there's some mental health issues going on. Still, cops were called out to Walmart for disturbance, and Mr. Schultz is wandering around that parking lot, approaching strangers, yelling some racial slurs. He's also damaging some side mirrors in a car on the lot. And he also committed a retail theft at the Walmart before doing all this. I see that there was some obstructive or resistive behavior here. He's alleged to be violating a condition of bail, necessitating the bail jump charge. And I recognize he also has a prior bail jump conviction. So I think some cash is appropriate here. It is CHRISTINE.
And just to clarify, the bail condition that was violated, that was the standard no new crimes. There wasn't a specific condition.
Hold on.
It didn't look like there was a specific condition of bail that was allegedly violated. I just wanted to clarify that.
I bet you that's right. 1 second. Yeah, that's correct. It's the no new crimes violation.
Okay, and Attorney Sheehan, your position on bail?
What's the bail jumping from?
No, there's multiple conditions of every bond. One of those is that you not pick up any new crimes.
Yeah.
The other one is showing up to all your court dates and that you not harass and intimidate any of the victims or witnesses. So because you picked up new criminal charges, that's called bail jumping.
Oh, okay, I didn't know, when I missed my initial court date.
What you're saying is being recorded right now and it can be used against you in your new cases. So
I'll be okay. The court date that I missed, recently, right, there's one missed court date on there.
I think all of them were in 2022 or 2021 that I heard Attorney Blair
yeah.
reference,
Okay,
unless you're aware of a
so
more recent one, sir.
what kind of months am I talking about here?
I don't know. Nobody's making an offer. I'm a court commissioner. I can't even take a
yeah,
plea and sentence you. I could take a plea, but I can't sentence you. So you're gonna find out more about that. We're addressing bail right now. The state's made their recommendation. Attorney Sheen was trying to get information from you so he can make an argument on your behalf.
Okay. Okay, sorry, I didn't know the bill jumping one hurts a lot.
you good?
Yeah, it should be good.
Okay. Okay, so I would object to the ban from all Walmarts. That doesn't necessarily make sense to me. If from that specific Walmart, perhaps, I understand. The no contact with the Christine and the other individual, I believe those are just the witnesses in the case of the alleged victims. No objection, I understand. I would object to the consideration of the failures to appear. They are from 2021 and they appeared over a span of 4 months. I think that's too remote to justify consideration. There were mentions of the alleged retail theft was $30. So I don't, again, taken in context with the mental health concerns that were expressed, I don't see how that ends up with $750, which would result in his continued incarceration, not exactly great for one's mental health. I would think that would justify, as is recommended in the public safety assessment, pretrial supervision rather than cash bail that would keep him in jail.
And any response from the state?
A ban from all Walmarts is the same level of treatment we would give to any retail victim, any Quick Trip, any Bon Mauer, any Kohl's, any thing like that, because they the entity as a whole, Walmart, deserves protection, not just the one Walmart that we're talking about. And then furthermore, I believe the no contact with Patrick C. and Christine S. perfectly reasonable.
Well, I'm not sure that they
I
were
didn't object to
objecting.
this.
Okay, fine.
I didn't object.
Right, and then yeah, I mean, look, I think the warrant history, excuse me, the failure to appear history I reference is perfectly soon enough for us to consider, and it clearly shows that Mr. Schultz has a hard time coming to court. So that's why I'm asking for some cash.
All right, well, I think there's a need for some cash bail here. The warrant history is a bit dated, but we're not talking decades. And it was quite a few failures to appear. Then we have him kind of denying as to who he was when law enforcement has contact with him, resistive behavior. Were they the worst resisting or obstructing that I've seen? No. And I don't want you to make any comments, Mr. Schultz, because today's not a trial.
Okay.
Everything's being recorded. I think Attorney Sheehan was trying to warn you of that earlier. He doesn't want you to say anything that could be used against you later on. They're gonna get you a lawyer, and you'll have an opportunity to talk to your lawyer, and that's probably at the time you want to make statements is when they get you assigned counsel and not on the record here.
Okay, there's a lot more than I thought.
Yeah, well, it can add up quickly when you're out on bail. It can add up quickly when you're allegedly not compliant with law enforcement. There is the history of that. He's been convicted of that previously, as noted in the repeater allegation. He is charged as a criminal repeater.
I was in rehab for that case that I missed recently.
Or was that case dropped?
I don't think they said you missed anything.
Well, again,
Okay.
Yeah, let's.
Okay,
you
so-
seem to think there was a more recent
Yeah.
failure to appear. I think the most recent one that they had was 2022. So
Okay,
if you're talking about having been in rehab from, I don't know,
Okay,
was it
that's-
April
that's fine.
2021 all the way up to September of 2022? Then I'm happy to hear that that's relevant information, of course. But those are the failures to appear that they're talking about.
okay,
So bottom line is, I think there's a need for some cash bail at this point to assure appearance in court. I think given the nature of the charges, it can be at a lesser amount. I'll set it at $400. I am gonna order a ban from all Walmarts. I think they could probably do that as a corporation and say, we don't want you there. I think they're entitled to that protection, and I don't know why we would say, yeah, fine, you can go to some other Walmart as long as you're not at the one there. Most of these Walmarts, I'm sure, corporate chains, not like different businesses owned by some small business owner. So I think they're entitled to that protection, and I'll order the no contact with Patrick C. and Christine S.
I can see, I don't.
You probably don't know who they are. They're
Sorry.
they're witnesses or victims of the charges. You've got a copy of the criminal complaint that's going to give you a little more information. Your lawyer is going to get a copy of the police reports that'll spell that out in greater detail for you, but you want to talk about those things with your lawyer. Bottom line is, you probably don't necessarily know who these people are or have any reason to have contact with them again.
Okay,
All right?
awesome.
Any other questions?
My bad for.
It's all right.
Nothing further.
You're gonna have to sign some paperwork and we'll be adjourned, all right?
Right this way with the shoulder. Next up is Joshua Hendrickson.
Great, we'll go on the record in the state of Wisconsin versus Joshua Hendrickson. It's 25 CF 2616 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Joshua Hendrickson appears in person in custody alongside Attorney Connor Sheehan. He is eligible for state public defender representation. He's received a copy of the complaint. I'll waive its formal reading. That being said, there is no address on it, so we do need to get an address. Do you have?
I use a PO box right now. I would my car.
But the question is to where we can send notice. So if it's,
Uh,
is a PO box acceptable?
Yeah, PO box
That's
is
okay.
acceptable. Do you know the number?
Yeah, 171.
One- Did you say 171 or 471?
No, 171.
All right.
171.
And I think the clerk needs to know the city and zip code for that.
Not more than 52572.
Okay.
Anyway.
And the other thing is you could always sign up for text message reminders until you get something other than a PO box. We'll make a finding of probable cause for the charges and are not guilty plea to the misdemeanor. There's a PSA report. It recommends cash bail, state's position on bail.
I'm requesting a $25,000 cash bond in this case. I'm asking that the defendant have no contact with victim one. For the purpose of bail notes, I believe the abbreviation, the initials are DLL, and that the defendant be banned from the 100 block of Maple Court in Mount Horeb. I would also ask that as a condition, the defendant be prohibited from acting as a caregiver for any non-relative individual. So, Commissioner, this is an incredibly serious case. It involves an allegation that Mr. Hendrickson, who's 42 years old, was acting as a caregiver for the alleged victim in this case. And the alleged victim here is a person who has significant physical health issues, including multiple sclerosis. The defendant in this case repeatedly sexually assaults her by performing oral sex on her, forcing her to perform oral sex on him, ejaculating in her mouth, trying to have penis to vagina and penis to anus sexual intercourse with her. And then the victim even says that she pushed him away, told him no a number of times. For what it's worth, he also uses her debit card a large number of times without permission, stealing about $300 from her. Mr. Hendrickson gives various statements which corroborates the victim's statements, but claims that the encounters were consensual. Still, it's incredibly concerning. This is an Act 3 eligible offense. Mr. Hendrickson's never been, to my knowledge, he's never had any missed court appearances, and I don't believe
I think the PSA suggested that he didn't have any prior convictions or failures to appear.
Right, and that's my understanding too. So but still, when we look at this through an Act 3 lens, it's incredibly concerning. It merits a high amount of cash. Here, the alleged victim needs particular protection. Mr. Hendrickson knows where the victim lives and has allegedly taken advantage of this victim over a period of time. So the individual victim here is certainly in need of protection and intimidation, but also the general public at large needs to be protected from this type of conduct. So look, I think that the $25,000 is reasonable. I feel it fairly balances the fact that we're talking about someone who has no Act 3 eligible priors, but we're also looking at a case where there's no obvious affirmative defenses, where, you know, Mr. Hendrickson intimately knows the victim. So I think that $25,000 is appropriate.
Attorney Sheehan?
Yes, thank you. Just to start, there may not, I can't say whether there's an affirmative defense. Consent is an exculpatory defense, though. I will say that first and foremost. Second of all, the no contact, the physical ban, the prohibited is from acting as a caregiver, no objections. As far as protecting the alleged victim, that can be achieved with the pretrial supervision and electronic monitoring that are requested or recommended rather by the public safety assessment. As far as Act 3 justifying $25,000 cash bail, what is there other than the allegation and the evidence as proffered within the complaint? He has no criminal history, no record of even criminal charges, to my knowledge, definitely not any convictions. What we have is one allegation, and that justifies $25,000 under Act 3. Under the totality of the circumstances, I don't see how that's the case. I don't see how we can just give someone $25,000 cash bail because they are charged with something. We have other structures in place, pretrial monitoring, electronic monitoring, pretrial services to account for that. Innocent until proven guilty is supposed to mean something, and it still should. Being charged with an offense is not a conviction, and I would ask the court to give a reasonable amount of money at the very least, $5,000 and maximum release conditions.
Right. And any response, Attorney Valerio?
I think this court is faced with cases like these all the time, where we have someone who's never been convicted of a crime before, but they nonetheless commit or alleged to have committed an incredibly serious case. Mr. Hendrickson is alleged to, over the course of several days, sexually assaulted someone who physically probably couldn't resist him that well. And I think the Act 3 statute applies in a case like this. Look, I think that I put it before, $25,000 for several Class B felony cases. I think that's perfectly reasonable, considering when, you know, if we're talking about maybe a different kind of case or a defendant with maybe more prior convictions or failure to appear, they probably get way more than that. I think $25,000 is reasonable.
All right.
If I may, Act 3 does apply. It should be $0. Act 3 does apply. That's why this isn't a $0 as far as ensuring his appearance to court. That's all.
All right. Well, so Act 3 allowed the court to take into consideration the need to protect the public under the totality of the circumstances. One of those factors is the prior violent history. Obviously, that's in Mr. Hendrickson's favor. The failure to appear risk or analysis, that's a mixed bag. In his favor, that he's got no failures to appear because he's never had any criminal record. I am concerned about whether he would show up in court. This is kind of one of those cases where if he gets convicted of these charges, it would be exceedingly hard to imagine a court not sending him to prison for a long time. This is an absolute abuse of trust if what the state alleges is true. And I don't know, it's going to play out. And as Attorney Sheehan notes, there's defenses other than affirmative defenses, a defense that I didn't do it because he got consent. There's a credible accounting of the offense by the victim. I'm not sure that Mr. Hendrickson's explanation of what happened and that he had consent is all that plausible to me, but a jury's gonna have to decide that. But if we didn't even have Act 3, this would be a substantial cash bail case because of the incentive not to appear when you're looking at something where this just, in my opinion, would not be a probation case. It would be a lengthy prison case, and that provides incentive for anybody not to appear. I do need to take into account the things that are in Mr. Hendrickson's favor. I think a lesser amount of cash bail than 25,000 is sufficient to assure appearance and protect the public. But I'm also going to order pretrial services. I'll set $15,000 cash bail if that's posted. You got to report to pretrial services no later than 10 a.m. on the business day following your release. They've given you that information, Mr. Hendrickson. They're on the 5th floor of the Dane County Courthouse. If you do post, make sure you're there. If you're not, that cash bail would get forfeited, be gone, and there'd be a warrant. And then we'd be talking about something probably a lot more than $25,000 cash bail. I'll order a ban from the 100 block of Maple Court in Mount Horeb. Order that they use GPS to make sure that you comply with that. I think the victim's entitled to that added protection. Obviously a no contact direct or indirect with DLL. And I am going to order that you not engage in any caregiver capacity. I think the caveat or exception, the state was allowable if it was a for a relative. So you can't act in a caregiver capacity for any non-relative. Should we get a prelim set in the next 10
Yes,
days?
please.
Okay, we will do that and we are adjourned.
Sorry. The other one is, I'm already got a lot of property, I don't take my hand on the street. I'm already compliant with that problem.
Okay.
That's fine.
Right this way. Next up is Michael Johnston.
On the record in the state of Wisconsin versus Michael Johnston, it's 25 CM 2761 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Thank you. Michael Johnston appears in person in custody alongside attorney Connor Sheehan. He is eligible for representation from the State Public Defender's Office. We've received a copy of the complaint. We'll waive its reading. That being said, I do need to update the address. Whenever you're ready.
Oh, it's SIMONSON.
Okay, it's just misspelled. I apologize. So it is 417 Simonson, but it's Simon S-O-N Street.
Got it. All right, I'll enter not guilty pleas after finding probable cause and the state's position on bail.
I have no objection to a signature bond. I would ask that the defendant have no contact with Keith H., that the defendant not use or possess any alcohol, and that he be banned from any Dollar General location. It looks like a notation I have is that the victim in this case verified that Mr. Johnston was terminated from the Dollar General location and he's banned from the store.
Okay, any issue with the signature on the recommended conditions?
That's not.
No objections.
Okay, we'll order a signature bond. Conditions will be a ban from Dollar General stores that you not possess or consume alcohol and have a no contact direct or indirect with Keith H. And we'll be adjourned.
Next up is Terrence Carr.
Go on the record in the state of Wisconsin versus Terrence R. It's 25 CF 2619 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
Terrence Carr appears in person in custody alongside attorney Connor Sheehan. He is not eligible for representation through the Office of the State Public Defender. We've received a copy of the complaint. We'll waive its formal reading. The address is correct.
Okay, and Mr. Carr, the bailiff gave you the public defender info. You have the absolute right to an attorney. Attorney Sheen will help you here today. Can't hire one later on. You could reapply with the public defender or apply for a county attorney. I'll make findings of probable cause, state's position on bail.
I'm requesting a $1,000 cash bond in this case with the condition that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription. I think the prevailing basis for why we're asking for cash is because this is a Class C felony. There's a potential for lengthy confinement, which creates a heightened incentive not to come to court. In this case, it looks like that there was suspected crack cocaine in Mr. Carr's pocket. That was tested presumptively positive for cocaine. It weighed 8.4 grams. There was indicia indicating that looks like there were baggies found in his person, a scale in his vehicle with crack cocaine residue, along with 9 prepackaged cannabis products and sandwich baggies. Furthermore, it looks like he was previously convicted of possession of THC charge and a misdemeanor bail jump back in 2020. So I think that some cash is needed.
One moment, please. Thank you. I appreciate the state's concerns. It is a Class C felony. There is potential for confinement. That being said, $1,000 is simply beyond Mr. Carr's reach, regardless of the eligibility finding at this moment in time. Goodness knows that can change. And also, frankly, having looked through the eligibility experience myself, it can be cryptic at points. I would ask the court to order $250 cash bail so that Mr. Carr can actually afford it.
All right, any response from the state?
No.
I'm gonna give Mr. Carr a signature bond. I don't know that the weights here, despite the significant potential penalties, are such that I can expect some super long prison term if Mr. Carr is convicted. So I'm willing to give him a signature bond. I'll order that you not use or possess controlled substances or drug paraphernalia without a valid prescription. As to time limits.
Waived.
Okay, we are adjourned.
Next up is John Shields.
Go on the record in the state of Wisconsin versus John Shields II. It's 25 CM 2755 appearances.
The state appears by Assistant District Attorney Thomas Valerio.
John Shields appears in person in custody alongside Attorney Connor Sheehan. We've received a copy of the complaint. We'll waive its formal reading. He is eligible for representation through the State Public Defender's Office. I will say he has other pending charge and he already has an attorney, so I'm sure my office will appoint him said attorney. The address, though, on the complaint, we do need to update.
Okay, whenever you're ready.
So what is the correct address?
Well, for mailing purposes?
Yes.
Okay, for mail purposes is 3740 Token Road, DeForest, Wisconsin, 535. Actually, sure.
I think the clerk can probably find the zip code.
It's my uncle Jeff.
Okay, and do you know,
That's good for
will
me.
mail get
That's okay.
delivered there if we send it in care of your name, or do we need to send it in care of his name?
That's all they need to know.
Oh, either way, if I prefer you just put carry his name, that way he's not
Sure, what's his name?
Jeff Schwartz.
Okay, and is that SCHWARTZ?
Yeah.
Okay, we will do that. And you could also always sign up for text message reminders if you got a cell phone. I'll make findings of probable cause, enter not guilty pleas to the charges. State's position on bail.
I have no objection to a signature bond. I would ask that the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription, and that he not use or possess any alcohol, that he be banned from the state and Langdon ban area.
Any objections? They're asking a ban from the State Street Langdon area per the ban map that you not use or possess alcohol or controlled substances or drug paraphernalia without a valid prescription.
So no objections to the signature bond, to the possession of controlled substances without a prescription, and nor to the no drink. The St. Langdon area, I don't necessarily see as relevant. I don't think that's a nexus to borrow the court's word to this offense. Especially as someone who's unhoused, Porchlight is in the area that's where he's going to be able to get any of the services available to them.
They already did an application and a walk. So
Especially if he's moving to Porchlight, as he has said to me, he's already done an application and a walkthrough to Porchlight, so he would be moving into that area. So I'd ask the court in order to facilitate his getting housing, which is the most difficult resource to achieve for someone who is unhoused, to not order that ban.
All right, and what's the address of where he's gonna be moving to?
Oh, it is, I believe it's, 324, it's on this thing.
Is it 306 Northbrook?
No, they parked my bike on State Street too and locked it there. Cause I was on my bicycle taking my dog for a walk when they approached me. I don't know, I take my dog, if I'm gonna be downtown, I'm gonna be taking my dogs for a walk downtown, and I didn't do anything to violate anybody.
Okay, well, you probably don't want to make any statements, because. I got you.
I'm not trying to fight anything, I just don't want Yesterday, it's the right check, he shot, I had to get my dog. It's my boss was supporting it. I think it's the same. Okay.
Yeah.
I'm sorry, you said 324, is that East or West Mifflin?
East Mifflin, I believe. I think my attorney might be able to look that or stay where I want. But I know what the place looks like.
So those are apartments. I don't think so. Hold on.
Yeah,
I guess it's not the address that I'm familiar with for Porchlight.
It's a house that they rent out.
Oh,
Yeah,
that's one?
it.
Okay, so,
It's got like 12 units in it. It's 3 floors.
okay,
Bottom they said will be staff.
okay, so 324 East Mifflin does
Yeah.
line up with with the description
That's right at the wall.
that Mr. Shields has made to me. So I would represent to the court that that is the address he's talking about.
Well, I'm not sure that that's within the ban area though.
Regardless, I would say that that is where most of these services that someone who is destitute would take advantage of are.
It's about in between there and the first time place where I'd be.
All right, well, I'm willing to go along with the signature bond. I'm gonna order that you not use or possess controlled substances or drug paraphernalia without a valid prescription, that you not possess or consume any alcohol. I see this as a different case than, it was our first case or one of the first cases where I didn't order the State Street Langdon ban. He's basically fallen down drunk. It is a known problem area for people who congregate there and do that. There are other ways for you to get services. I'm not convinced that the address you're going to be staying at is in there, and there are lots of other places you can walk your dog. So I will order the State Street Langdon ban. They'll give you the map. Please pay close attention to that because they know who's not supposed to be there, sir, and so they'll arrest you if you're there. So don't walk in to that area. And if there are issues, you can always bring those up with your lawyer and they can file a motion to review the bail and it can be addressed later on. We are adjourned.
Thank you, Your Honor.
Yeah, you're welcome.
That's everybody that's at.